1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်969 In the matter of the estate of ဦးကျော်ခေါင် deceased versus NYUNT applicant ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil miscellaneous application before ဦးကျော်စံဦး Judge in the matter of the estate of ဦးကျော်ခေါင် deceased versus NYUNT applicant Code Fees Act Section 5 Reference by Registrar of the Original Site Number 11 of Schedule 1 of the Code Fees Act Complete assets and properties of the deceased to be shown in the Annexure A Section 191(1) of the Code Fees Act applicant to find a valuation of the property in the form set forth in the third schedule, Rule 4 of the Rules of Procedure in the grant of letters of administration of the rules and orders of the High Chief Court, affidavit of valuation and affidavit or certificate of valuation of immovable property to accompany the application. Under Section 5 of the Code Fees Act, the Registrar Original Site has referred these points whether the applicant, a Burmese Buddhist lady, should pay the court fee on half the value of the properties left behind by her late husband, who was also a Burmese Buddhist, in respect of which she has applied for letters of administration, since she is already the owner of the other half under the Burmese Buddhist law, and how the valuation of the properties is to be set forth in the application. Hell, number 11 of Schedule 1 of the Code Fees Act says the fee is payable on value of the property in respect of which the grant of letters is made. The letters are applied in respect of the deceased property, which may include, besides his own, it is the corpus which is important and not its component parts. It will be beyond the scope of the court in such cases to find out at the outset who else are interested in the property besides the deceased. Accordingly, it is ruled that the entire and complete assets and properties of the deceased, as they stood at the time of his death, must be shown in the Annexure A of the application, and the appropriate court fee be paid in full upon the basis of the entire net valuation set forth by the applicant. In the Goods of Araton Stephen deceased 1927, 1928, 32, Kalagata, Weekly Nodia 799. In the Goods of Probat Chandra Barua, deceased ILR 1946, 1, Kalakata 77. In the estate of Upo King, deceased 1918, 11, Burma Law Times 258, Matamya vs. Mangwei Yun, 2, Upper Burma Rulings 1914, 1916, 74, Mat Yi Mie and 3 versus Maung Ba Maung ILR 2 Rangoon 123 127 Manue versus Mat Sai Da ILR 7 Rangoon 758 Masanyo and another versus Mountain AIR 1930 Rangoon 190 refer to Hellfather Section 191 1 of the Code Fees Act, which says that no grant of letters of administration shall be made upon an application for such grant until the applicant has filed in the court a valuation of the property in the form set forth in the third schedule of the Act. It is imperative where an application for letters is made to the High Chief Court, Section 19H of the Code Fees Act directs that a notice of the application shall be given to the Financial Commissioner, who may penalize the applicant under Section 19E of the Act if he paid too low a court fee thereof, and Rule 4 of the Rules of Procedure in the grant of letters of administration, page 206 of the Rules and Orders of the High Chief Court, affidavit of valuation and affidavit or certificate of valuation of immovable property in accordance with Rule 17 must accompany the application showing the name of the valuer inter alia, if any, on the basis of valuation adopted. Under Rule 18, the bailiff can make the valuation if request is made to the court for his service. Of course, the correctness of the valuation is a matter for the revenue authorities and not for the court to decide. In case the valuation is found or proved to be greater and too high, a court fee has been paid thereon. Remedy is open to the applicant under Section 19A of the Act. Judge. This is a reference under Section 5 of the Code Fees Act submitted to me for decision at the instant of the learned registrar of the original site of this code, as a difference has arisen between him and the learned advocate for the applicant Donyo. In this case, the points raised are whether the applicant, a Burmese Buddhist lady, should pay court fee on half the value of the properties left behind by her late husband, who was also a Burmese Buddhist, in respect of which she has applied for letters of administration, since she is already the owner of the other half under the Burmese Buddhist law, and how the valuation of the properties is to be set forth in the application. The court is not concerned with the correctness of the valuation, but with the setting forth of all the properties correctly, or, in other words, with the true and correct assets of the deceased. The points raised undoubtedly are of general importance. No authority has been shown on the subject. In the Goose of Aranton, Stephen, deceased 1, Costello Judge, sitting on the original side of the Calcutta High Court, pointed out that the High Court, or a civil court, on an application being made to it for letters of administration has only to be satisfied that appropriate duty has been paid on the net valuation of the estate as set forth in the application, and it is no part of its business to check the correctness of that valuation, which test has been reserved for the revenue authorities to be performed by them, if considered necessary, after receipt of the usual notice of the application from the court. Civil courts ought not to concern themselves to check the valuation put upon the various items of property set out in the application or in the affidavit of valuation according to the form prescribed in the third schedule of the Court Fees Act, but they should merely satisfy themselves that the appropriate fee has been paid on the valuation declared by the applicant. The land registrar should merely satisfy himself that all the appropriate duty has been paid in accordance with and upon the basis of the figures which the applicant himself or herself put forward in his or her affidavit of valuation. If that valuation is not correct, it is the business not of this court, but of the revenue authorities to make such investigation as they think fit, and if they are so advised to move the code under subsection 4 of section 19H of the Court Fees Act in Civil Miscellaneous numbered 34 of 1966 of this code, Ji Mie, a daughter of the deceased by his first wife, Pu Li, made a similar application for letters of administration with the knowledge and consent of her own brother and sister, to which the present applicant, Donyo, opposed. The properties in both the cases are identical, but the valuations given are not the same. Being a fiscal matter, it is not unusual to hold an inquiry by the collector under section 19H3 of the Court Fees Act to come to a correct and uniform valuation of the properties for the purpose of assessment of court fee. If he entertains any doubt or is not satisfied with the valuation made by the applicant, or if the applicant does not amend the valuation to his satisfaction, he, collector, may move the court to hold an inquiry into the true value of the properties, as I have stated above. If it is the High Chief Court, the application must be made in its testamentary and intestate jurisdiction and not in its ordinary original civil jurisdiction. In the goods of Probate Chandra Barua deceased 2. In the goods of Probate Chandra Barua deceased 2. In the other case, the applicant Ji Mie denied that this applicant Donyo is the legal widow of her father, the deceased, and there was severance of filial relation between the deceased and his children, including herself. He also denied the applicant Donyo allegation that her mother Pu Li, also deceased, was divorced by her father. She also denied the applicant Donyo allegation that her mother Pu Li, also deceased, was divorced by her father. The applicant Donyo has no issue by the deceased. Thus, the important questions inter alia involved are whether the applicant donor was legally married to the deceased and whether Dobule was divorced by the deceased, the right to inherit and the quantum of interest of the applicant in the properties of the deceased depend upon the answer to these questions. Evidence will have to be shed if the court is desired to decide, but before any decision is made, the court is concerned with and is to look only at the estate of the deceased as it stood at the time of his death, for which rival applications for letters of administration have been made. In the estate of Upo King, deceased 3, which is the only authority on the point I could lay my hands on, it was held by Jan Chesh that the estate of a Burman Buddhist dying in the lifetime of his wife includes only half the property he died possessed of, the other half being his wife's property during their joint life, and the court fee is payable on half the property he died possessed of for the purpose of letters of administration. It is a short judgment, and it appears that it was a simple and straightforward case of a legal widow applying for letters of administration. If this was so, I have no quarrel with it, as under the Burmese Buddhist law, the wife, during their subsistence of the marriage, has interest generally in all the properties belonging to either or both. It is usual to regard all properties acquired by the spouses during the covenantal as belonging equally to the husband and wife, but when the kind of properties, for example, ပါရင် လက်ထပ်ဘွား နှစ်ပါးစုံ etc., the status of the couple, for example, အိမ်ထောင်ကြီး lesser wife, etc., and the rights of inheritance of the attached children against the surviving spouse are in question. The quantum varies. To illustrate the point, assuming that the applicant donor is the legal widow of the deceased and that Dobule was not divorced, I may mention that in Matamya vs. Mangwejun 4, it was held that the child of a first marriage was entitled to 3/4 of the jointly acquired property of the first marriage, and the second wife was entitled to 1/4. See also Mai Mie and 3 versus Maungpa Maung 5. In Manue versus Masaida 6, which was a case by the child of the first marriage against the stepmother for administration of the estate of her father deceased, where the estate was made up of Bayin property brought to the second marriage by the deceased, as well as of Napazong property of that marriage, the major portion having been inherited after the death of the first wife and before his second marriage, it was held that the attached child would get 3/4 of the said inherited property, which was brought in as Bayin, and the stepmother would get 1/4. If the deceased, however, inherited during the second marriage, the stepmother would be entitled to half. As regards နှစ်ပါးစုံ of the second marriage, it was held at that child would get only 1/8 share and the stepmother 7/8. See also Massanyo and another verses Mountain 7. Hence, it cannot always be said that the wife is entitled to have the properties on the death of the husband. It depends upon the special circumstances of each case. In the estate of Ubo King 3, is thus distinguishable. Number 11 of Schedule 1 of the Court Fees Act. C. The fees is payable on value of the property in respect of which the grant of letters is made. The letters are applied in respect of the deceased property, which may include, besides his own, it is the corpus which is important and not its component parts. It will be beyond the scope of this code, I think, in such cases, to find out at the outset who else are interested in the property beside the deceased. Accordingly, I rule that the entire and complete assets and properties of the deceased, as they stood at the time of his death, must be shown in the annexure A of the application and the appropriate court fee be paid in full upon the basis of the entire net valuation set forth by the applicant Donyo. In other words, her contention that the fee is payable on half the value of the properties is rejected. To answer the second point, reference is to be made to Section 191(1) of the Court Fees Act, which says that no grant of letters of administration shall be made upon an application for such grant until the applicant has filed in the court a valuation of the property in the form set forth in the third schedule of the Act. It is imperative, where an application for letters is made to the High Chief Court, Section 19H of the Court Fees Act, directs that a notice of the application shall be given to the Financial Commissioner, who may penalize the applicant under Section 19E of the Act if he paid too low a court fee thereof. In the Canada case referred to above, the applicant valued the properties in full, while the present applicant Donyo, as stated above, desired to pay only half the court fee on the value of the same properties. Valuation was worked out by a qualified architect and licensed surveyor and property valuer, and it may be more acceptable than that of the applicant Donyo. Enter Rule 4 of the Rules of Procedure in the grant of letters of administration, page 206 of the Rules and Orders of the High Chief Court. Affidavit of valuation and affidavit or certificate of valuation of immovable property in accordance with Rule 17 must accompany the application, showing the name of the valuer inter alia, if any, on the basis of valuation adopted. Under Rule 18, the bailiff can make the valuation if request is made to the court for his service. Of course, the correctness of the valuation is a matter for the revenue authorities and not for the court to decide, as I have stated above. in case the valuation is found or proved to be greater and too high a court fee has been paid thereon, remedy is open to the applicant under Section 19A of the Act. For all the reasons given above, I write that the same valuation as in the connected case be made in the present case also as advised by the Land Registrar.